അവകാശ നിയമത്തെ സംബന്ധിച്ച് പറയുകയാണ് എന്നോട് ആവശ്യപ്പെട്ടിരിക്കുന്നത്. ഞാൻ ഇന്ന് പ്രധാനമായി കോൺസെൻട്രേറ്റ് ചെയ്യുന്നത് ഹിന്ദു സക്സഷൻ നിയമത്തിലെ ഒന്നാമത്തെ ചാപ്റ്ററും ഹിന്ദു നിയമങ്ങളുടെ പൊതുവായ ഒരു ഇൻട്രൊഡക്ഷനുമാണ്. ഞാൻ ഇംഗ്ലീഷിലും മലയാളത്തിലുമായിട്ട് അത് അവതരിപ്പിക്കാമെന്ന് കരുതുന്നു. ഹൈന്ദവ നിയമങ്ങൾ അല്ലെങ്കിൽ ഹിന്ദു ലോസിൽ നമ്മുടെ ഇന്ത്യയിൽ ലഭ്യമായിട്ടുള്ള ഏറ്റവും ആധികാരികമായ ഗ്രന്ഥങ്ങളിൽ ഒന്ന് ഹിന്ദു ലോ ആൻഡ് യൂസേജ് ബൈ ജോൺ ഡി മെയിൻഡർ ആണ്. അദ്ദേഹം ഈ നിയമത്തെ സംബന്ധിച്ചിടത്തോളം അപകാരം ഉള്ള ഒരു ഗ്രന്ഥം പുറത്തിറക്കിയിട്ടുണ്ട്. അദ്ദേഹത്തിന്റെ മാഗ്നം ഓപ്പസ് അല്ലെങ്കിൽ ക്ലാസിക്കൽ വർക്ക് അല്ലെങ്കിൽ ഗ്രേറ്റ് വർക്ക് എന്നൊക്കെ സൂചിപ്പിക്കാമായിരുന്ന ഒരു പുസ്തകമാണ് ഹിന്ദു ലോ ആൻഡ് യൂസേജ് എന്നുള്ള അദ്ദേഹത്തിന്റെ പുസ്തകം. അദ്ദേഹത്തിന്റെ പ്രസ്തുത പുസ്തകത്തിന്റെ ഒന്നാമത്തെ എഡിഷനിൽ അദ്ദേഹം ഹിന്ദു ലോയെ കുറിച്ച് ഇങ്ങനെ എഴുതി: ഹിന്ദു ലോ is the oldest pedigree of any non-system of jurisprudence. Hindu law is the oldest pedigree of any non-system of jurisprudence. And even now, it shows no sign of decrepitude. Decrepitude എന്ന് വെച്ചാൽ പ്രായാധിക്യം അല്ലെങ്കിൽ ദൗർബല്യം. Hindu law is the oldest pedigree of any non-system of jurisprudence. ഏതൊരു നിയമത്തിന്റെയും വംശാവലി വെച്ച് നോക്കുകയാണെങ്കിൽ ഇത്രത്തോളം പഴക്കമുള്ള വംശാവലിയുള്ള ഒരു നിയമം ഹിന്ദു ലോ അല്ലാതെ മറ്റൊന്നില്ല. എന്നിട്ട് അദ്ദേഹം പറയാണ്, ഈവൻ നൗ ഇറ്റ് ഷോസ് നോ സൈൻ ഓഫ് decrepitude. Decrepitude മീൻസ് പ്രായാധിക്യമോ ദൗർബല്യമോ അതിന്നും കാണിക്കുന്നില്ല. A.M. ഭട്ടാചാര്യജി അദ്ദേഹത്തിന്റെ മറ്റൊരു ക്ലാസിക്കൽ വർക്ക് ഹിന്ദു ലോ ആൻഡ് കോൺസ്റ്റിറ്റ്യൂഷൻ എന്നൊരു പുസ്തകമുണ്ട്. അദ്ദേഹം A.M. ഭട്ടാചാര്യജിയുടെ പല പുസ്തകങ്ങളുണ്ട്. ഹിന്ദു ലോ ആൻഡ് കോൺസ്റ്റിറ്റ്യൂഷൻ ഉണ്ട്, മുസ്ലിം ലോ ആൻഡ് കോൺസ്റ്റിറ്റ്യൂഷൻ ഉണ്ട്, അങ്ങനെ പല പുസ്തകങ്ങളുണ്ട്. അതിൽ അദ്ദേഹത്തിന്റെ ഒരു ക്ലാസിക്കൽ വർക്കാണ് ഹിന്ദു ലോ ആൻഡ് കോൺസ്റ്റിറ്റ്യൂഷൻ. അദ്ദേഹം ഹിന്ദു ലോയെ കുറിച്ച് പറയുന്നത് ഇങ്ങനെയാണ്: ദ ഹിന്ദു ലോ ആസ് ആൻ ഏജ് ഓൾഡ് യെറ്റ് ആൻഡ് ഏജ്ലെസ് സിസ്റ്റം ഓഫ് ലോ. ആൻഡ് ഏജ് ഓൾഡ് യെറ്റ് ആൻഡ് ഏജ്ലെസ് സിസ്റ്റം ഓഫ് ലോ. The paramount thing to be noted is that even though it is antique or edition, it shows youthfulness of law. So it is, even though age old, yet it is ageless. One of the important features of the Hindu law is that Hindu law is not complete, comprehensive or consolidated code as known to the science of jurisprudence. ഇങ്ങനെ പലയിടത്തായിട്ട് കിടക്കുകയാണ്. എല്ലാം കൂടെ ഇന്ന് കൺസോളിഡേറ്റ് ചെയ്ത് ഹിന്ദു ലോ കംപ്ലീറ്റ് ആയിട്ട് കൺസോളിഡേറ്റ് ചെയ്ത് ഒരു സംവിധാനം നമുക്ക് ഉണ്ടാക്കാൻ സാധിച്ചിട്ടുണ്ട്. That is why it is not complete. It is not comprehensive or consolidated code as known to the science of jurisprudence. But system highly rooted in Vedas or Smrtis, announced in Smritis or Dharmasastras, expounded by ancient commentators, and supplemented and varied by custom and usage. So it is available in Vedas or Srutis. It is yet available in Srutis and Dharmasastras. It is available in commentaries. It is available in digests, but it is not codified. The Srutis or Vedas are the fountainheads of Hindu law. The fountainheads of the Hindu law is Srutis or Vedas. Smritis or Dharmasastras developed it, expounded it, and came to be recognized as authoritative statements of law administered by kings and rulers. We know law is never static. It is always dynamic. What law shows, law reflects the habits, customs, and cultural norms of the community. Rightly speaking, the law is the manifestation of the aspirations and ambitions of the society. Hindu law, as every other system of law, was never static, but always dynamic, empowering, and progressive. വാസ്തവത്തില് ഹിന്ദു ലോ എന്ന് പറയുന്നത് ഡൈനാമിക് ആണ്, നിരീക്ഷണത്തെയും അനുഭവജ്ഞാനത്തെയും അടിസ്ഥാനമാക്കി വളരെ പ്രോഗ്രസീവ് ആയിരുന്നു. There are four main recognized sources of Hindu law. ഹിന്ദു സക്സഷനെ കുറിച്ച് പഠിക്കുമ്പോൾ അല്ലെങ്കിൽ ഹിന്ദു കോഡിലെ മറ്റേതെങ്കിലും നിയമത്തെ കുറിച്ച് പഠിക്കുമ്പോൾ നമ്മൾ അപരിത്യാജ്യമായി അറിഞ്ഞിരിക്കേണ്ട ഒന്നാണ് ഇതിന്റെ സ്രോതസ്സുകൾ. സ്രോതസ്സുകളുടെ പഠനം ഇല്ലാതെയുള്ള നിയമപഠനം വാസ്തവത്തിൽ നമുക്ക് ഭാഗികമായ പഠനമേ നൽകുന്നുള്ളൂ. അതുകൊണ്ട് വാട്ട് ആർ ദി സോഴ്സസ് ഓഫ് ദി ഹിന്ദു ലോ ഈസ് ഇമ്പോർട്ടന്റ്. വാട്ട് ആർ ദി റിക്കഗ്നൈസ്ഡ് സോഴ്സസ്? As I said earlier, the first source is nothing but the Shruti or Vedas. Second one is Smriti or Dharmasastras. Third one is commentaries and digests. And fourth one is custom. Lastly, now we can say we have another source, another two more sources. Those are legislations and precedents. Generally speaking, there are three sources for law. One is legislation or statutory law. Second is precedents or case law. Third one is customs, which are age-old in nature. Customs are recognized as source of law because the maxim says via tuta, via trita. Via means way, body. Via tuta, via trita. Frequented path is a reliable path. So customs are recognized as source of law. Likewise, as I said earlier, there are main four sources for Hindu law, apart from legislations and the precedents. Those are Shrutis. First one is Shrutis or Vedas. Second one is Smritis or Dharmasastras. Third one is the commentaries and digests. And the fourth one is the custom. The first one, Shrutis or Vedas. As most of us know, The Smritis are believed to be of the divine origin. And it contains the very words of deity. They include 4 Vedas. First one is Rik, second one is Yajur, third one is Sama, and fourth one is Atharva. It is the firm belief that it is the firm belief of the Hindus that Vedas are the work and woof of the Hinduism. So, the Smritis are considered as the primary source of Hindu law. They contain very little legal literature. For more studies, I suggest you read article written by Justice P.B. Yajendra Gadkar, former Supreme Court judge. This article is historical background and theocratic basis of Hindu law. Historical background and theocratic basis of Hindu law. ഇതിൽ ഏറ്റവും സമക്കായിട്ട് അദ്ദേഹം ഹൈന്ദവ നിയമങ്ങളുടെ അല്ലെ ഹിന്ദു ലോസിന്റെ ആവിർഭാവത്തെ കുറിച്ച് മനോഹരമായ ഒരു ആർട്ടിക്കിളാണ്. ഇത് AIR പബ്ലിഷ് ചെയ്തിട്ടുണ്ട്. AIR 1963 ജേർണൽ സെക്ഷൻ പേജ് നമ്പർ 18. AIR 1963 ജേർണൽ സെക്ഷൻ പേജ് നമ്പർ 18. One thing is sure, Shrutis or Vedas contain very little legal literature. Hence, we derive very little light from the Vedas in regard to any question of positive law. The second source I told earlier, Smritis or Dharmasastras. Even though the Vedas are that of the divine origin, Smritis or Dharmasastras are of the human origin. These are of the human origin and contain precept of God, regulated and practiced by rishis, saints, sages of the great antiquity. പുരാതന കാലങ്ങളിൽ ജീവിച്ചിരുന്ന ഋഷിമാരുടെയും സന്യാസിമാരുടെയും മറ്റും ധർമ്മോപദേശമാണ് ഇതിന്റെ അടിസ്ഥാന സംഗതി. The most important element, as far as we have to keep in mind, is that Smritis are the principal source of Hindu law. Smritis are the principal sources of Hindu law. Among the Smritis, there are 3 important Smritis which are to be kept in mind while studying the Hindu law. The first one is Code of Manu, known as Manusmriti. Second one is Code of Yajnavalkya, known as Yajnavalkya Smriti. Third one is Code of Narada, known as Narada Smriti. These are the main Smritis, Manusmriti, Yajnavalkya Smriti, and also Narada Smriti. There are a number of other Smritis also. Parasara Smriti, Vyasara Smriti, Samavarta Smriti, Devala Smriti, etc. The Smritis are, as I stated earlier, the principal sources of the Hindu law. The three main important Smritis are the Manusmriti, Yajnavalkya Smriti, and Narada Smriti. Manusmriti has always been treated by Hindu saints and sages as the paramount authority of Hindu law. Manu is regarded as the first ancestral lawgiver of the mankind. Age of Manusmriti is not certain, but it is fixed at 200 BC. Next one is Yajnavalkya Smriti. The authority of the Yajnavalkya is next to Manu. Its date is arrived at in or about 300 AD. In Ramachandra Martanda Vikar, Ramachandra Martanda Vikar, Wikar, Vikar versus Vinayaka Venkatesh Kothekar, AR 1914 Privy Council, page number 1. ഈ ജൂനിയർ ലോയേഴ്സിന്റെ ശ്രദ്ധയ്ക്ക് വേണ്ടി പറയുകയാണ്. നമ്മള് പ്രിവി കൗൺസിൽ ഡിസിഷൻ എങ്ങനെ ഇമ്പോർട്ടന്റ് ആയിരിക്കുന്നു, സുപ്രീം കോടതി ഡിസിഷൻ എങ്ങനെ ഇമ്പോർട്ടന്റ് ആയിരിക്കുന്നു ഒക്കെ നമ്മൾ മനസ്സിലാക്കി വെക്കേണ്ടതാണ്. By virtue of the Article 141 of the Constitution of India, the law laid by the Supreme Court is the law of the land. It says that the law declared by the Supreme Court shall be binding on all courts within the territory of India. So it has a precedential value of very importance. Likewise, Privy Council decisions are also important. If to that point, the Supreme Court decisions are not available. Article 374 of the Constitution of India. Article 374 of the Constitution of India, subclause 2 says, Article 374 is dealing with provisions as to judges of the Federal Court and proceedings pending in the Federal Court and before His Majesty's in Council. That is Article 374. Article 374 subclause 2 says that all suits, appeals and proceedings, civil or criminal, pending in the Federal Court at the commencement of this Constitution shall stand removed to the Supreme Court, and Supreme Court shall have jurisdiction to hear and determine the same. And the judgments and orders of the Federal Court delivered or made before the commencement of this Constitution shall have same force and effect as if they had been delivered or made by the Supreme Court. So that is very important. The judgments or orders I am reading and I am stating from the Article 374, clause 2 of the Constitution, which says that judgments or orders of the Federal Court delivered or made before the commencement of the Constitution shall have same force and effect as if they had been delivered or made by the Supreme Court. അതുകൊണ്ട് സുപ്രീം കോടതിക്ക് പ്രത്യേകമായ ഒരു വിധി ഈ ഒരു പ്രത്യേക പോയിന്റ് ഇല്ല. അതേസമയം അക്കാര്യത്തെ കുറിച്ച് പ്രിവ്യൂ കൗൺസിൽ ഡിസിഷൻ ഉണ്ടെങ്കിൽ ആർട്ടിക്കിൾ 374(2) അനുസരിച്ച് സുപ്രീം കോടതി വിധിയുടെ പോലെ തന്നെ പ്രാമുഖ്യം ആ വിധികൾക്കുണ്ട്. അതുകൊണ്ട് അത് ഓട്ടോമാറ്റിക് ആയിട്ട് 141ന്റെ പരിധിയിലേക്ക് വരും. In Ramachandra Martanda Vikkar versus Vinayaka Venkatesh Kothekar, AR 1914, 1914, Privy Commission page number 1. Justice summarily refers to Yagnavalkya as belonging to 2nd century AD. Many commentaries have considered Yagnavalkya as the basis of their commentaries. The important point is that Yagnavalkya Smriti is concise, more systematic, better arranged than manuscript. It is concise, it is systematic, and it is better arranged than manuscript. And third code is Narada Smriti. This work is ascribed to sage Narada and is the first to give us a legal code. As far as Hindu law is concerned, first legal code is traced from Narada Smriti. Narada's work is based on essentially Manu and Yagnavalkya, though Narada differs from Manu in several aspects. A remarkable feature of the Narada Smriti is that it is the first Dharmasastra to accept the principle that king-made laws should override the rule of law laid down in the Smritis. The king-made laws should override. King-made laws should claim superiority over the rule of law laid down in the Smritis. Narada is recognized for his advanced and progressive views on several matters of law. He is also categorical that custom is powerful and it overrides the text of sacred laws. Custom is powerful, it overrides the text of sacred laws. He recognized the allotment of shares to widows and unmarried sisters in partition among sons. He also recognizes the separation and the remarriage of women on certain circumstances. Apart from these three codes, another very important source of Hindu law is Arthasastra of Vishnugupta Chanakya, who is also known as Kaudanya. As many of us know, he was friend, philosopher, and guide of Chandragupta Maurya, who established a mighty empire in the 4th century BC. According to scholars, no study of Hindu law, Hindu legal literature, or Hindu polity, no study of Hindu law, Hindu legal literature, or Hindu polity can be complete or meaningful without a reference to Arthashastra of Vishnugupta Chanakya or Kaudilya. Although Arthashastra of Vishnugupta Chanakya has been mentioned in numerous edition works, authentic text of the work was not available till it was discovered in 1909, when it was translated and published by Dr. Saima Sastry. Dr. P.V. Gajendra Gadkar, in his historical background, in his famous work, the article, The Historical Background and the Theocratic Basis of the Hindu Law, which is published, as I stated earlier, year 1963, Journal section, page number 18, 18. Dr. P.B. Gajendra Gadkar says, the publication of the Dr. Samasastri of Arthashastra of Kaudilya in 1909 was an epoch-making event in the history of the research of Hindu law. Arthashastra of the Kaudilya is not a Smriti or a Dharmasastra. Rightly speaking, it is an independent work. It is a mastery treatise of ancient Indian polity, and I will say it is the reservoir of rules, inter alia, relating to the duties of a king, his administration, including the administration of justice, laws, courts of law, legal procedure, taxation, rights of women, marriage, divorce, philosophies, sociology, economics, science, and hygiene. Before the discovery of the Arthashastra, as I stated earlier, in 1909, several European scholars, including Sir Henry Mayen and J.S. Nelson, severely criticized the ancient Hindu law in many regards. But after finding the Arthashastra and after publication of the translation of the Arthashastra in English by Dr. Samasastri, the opinions of these scholars changed substantially. The presentation of the Arthashastra to the whole world by its translation, rightly speaking, administered a healthy shock to those critics of Hindu law. It is fair on the part of the European scholars that most of the scholars confessed that their comments were totally unjustified. I have mentioned the Srutis or the Vedas, Smritis or Dharmasastras, and then about the Arthashastra. Likewise, another source is the commentaries and the digests. The commentators, while professing to interpret the laws, lays down in the Smritis, introduced the changes in order to bring into harmony with the usage. This is the dynamics of the Hindu. They introduced the changes in order to bring the Smritis into harmony with the usage in the society. When we go through the Hindu law, There are two main schools of Hindu law. One is Vidakshara and other is Dayabhaga. The commentary of the Yajnavalkya Smriti by Vigneshwara is known as Vidakshara school. Vidakshara school of Hindu law. So, commentary of the Yajnavalkya Smriti by Vigneshwara is Vidakshara school. He belongs to the orders of the ascetics, and his spirit is fixed with reference to his contemporaries and the patron, Chalukya king Vikramaditya of the Kalyan, AD 1076 to 1126. The Vidakshara school of Hindu law became supreme throughout India, except in Bengal and present Assam. Third, Vidakshara means the gift of God. In Bengal, Dayabhaga school was dominated, and the mastermind behind this school was Jimuda Vahana. Where Dayabhag means inheritance. Both these schools deal with the inheritance. Vidakshara school is divided into 4 minor schools: Benares schools, Mithila school, Maharashtra or Bombay school, which is also known as Western school, Western Indian school, and lastly, Dravidian school or Madras school, which is also known as Southern Indian school. Wherever laws of personal law are recognized, the rights and obligations of the Hindu are determined by the Hindu. Hindus were divided into 4 castes, we know. Brahmins, which was the priestly class; Kshatriyas, the warrior class; Vaisyas, the agricultural class; and also Sudras. Sudras were denied to study Vedas, etc. So the first 3 classes were called twice born or regenerates. The second birth is attributed to the study of Vedas or sacred literature and in performance of the sanskars or sacraments. All these are denied to Sudras, except sanskara of marriage. These classifications were of the considerable importance prior to the enactments of 1955 and 56. We know the Hindu Marriage Act. Other 3 enactments were in 1956. What is caste is also important as far as the present scenario is concerned. Especially scheduled castes, backward classes, etc. were an issue. The Supreme Court of India explained the meaning of caste in a wider sense and merely in the context of the 4 primary castes, which I mentioned earlier, in a celebrated decision, Arumugam versus Rajagopal. Arumugam versus Rajagopal. JER 1976. Supreme Court, page number 939. JER 1976, Supreme Court 939. Equivalent citation is 1976 1 SEC 863. 1976 1 SEC 863. Supreme Court in Arumugam versus Rajagopal very well narrated the meaning of the caste in its wider sense. After Constitution of India came into force, what is caste? What are the connotations and implications of the scheduled caste? Caste became considerable importance and consequences. For more references, I suggest 3 decisions, 2 Supreme Court decisions and 1 Delhi decision. Supreme Court decisions are 1 Arumugam versus Rajagopal, which I already stated. AER 1976, Supreme Court 939. Equivalent citation is 1976. 1 SEC, page number 863. 863. Second one is Principal Guntur Medical College. Principal Guntur Medical College versus Mohan Rao. That is also reported in AER 1976, Supreme Court 1094. Equivalent citation is of SEC is 1976 3 SEC, page number 411. Apart from these 2 decisions, those who are interested to study more can read Kassan Singh versus Union of India. Kassan Singh versus Union of India. AER 1980 Delhi, AER 1980 Delhi 60, and cases cited there it was. So Kassan Singh versus Union of India is a very good decision with a plethora of precedents. So 1976, sorry, AER 1980 Delhi, case number 60, and cases made mentioned in that decision. The application of Hindu law is concerned. The powers of the court in India to apply Hindu law to Hindus is derived from and regulated by certain statutes of the British Parliament and by imperial and provincial legislations passed during the period of British rule, which are still in force unless altered or repealed, and they are to be continued in force. For more details, kindly refer Article 372 of the Indian Constitution. Article 372. Article 372 of the Constitution says the continuance in force of the existing laws and their adaptation. So, imperial and provincial legislations are to some extent still useful for the practical purposes. Hindu law, as administered by the courts of India, is applied to Hindus in some matters only. One, succession. Next, inheritance. Then marriage, adoption, guardianship, family relations, wills, gifts, and partition. Succession, inheritance, marriage, adoption, guardianship, family relations, wills, gifts, and partition. Now, by 1955 and 56, to a certain extent, Hindu laws were modified, some laws were abrogated, and practically made a Hindu code. Four enactments are together known as code. So when statements and objects were published, they said first installment of the code, second installment of the code, third installment of the code, fourth installment of the code. So the first one is the Hindu Marriage Act 1955, Act 25 of 1955. Second one is Hindu Succession Act 1956, Act 30 of 1956. Third one is Hindu Minority and Guardianship Act 1956, Act 32 of 1956. And lastly, the Hindu Adoptions and Maintenance Act 1956, Act 78 of 1956. There were so many earlier acts which we can find in most of the Hindu law textbooks. Altogether, there were 14 enactments prior to the Hindu Code. Hindu Code means these four acts. The one is the Caste Disabilities Removal Act 1850, Caste Disabilities Removal Act 1850, Hindu Widows Remarriage Act 1856, Indian Succession Act 1825, Converts Marriage Dissolution Act 1866, Special Marriage Act 1954, Transfer of Properties Act 1882. There is that this act supersedes all of the Hindu law and asks you the transfer of property. The Majority Act 1875. This act fixes the age of the majority on completion of 18 years. Applies to Hindus except in the matters of marriage, divorce, and adoption. The eighth one was the Guardians and Wards Act 1890, Hindu Inheritance Removal Disabilities Act 1828, Hindu Law of Inheritance Amendment Act 1929, Child Marriage Estate Act 1929, Hindu Games and Learning Act 1930, the Hindu Women's Right to Property Act 1937. Lastly, Hindu Married Women's Right to Separate Residence Right to Maintenance Act 1946. In Yajna Purushadasni versus Muldas, Yajna Purushadasni versus Muldas, year 1966 Supreme Court 1119 1119, year 1966 Supreme Court 1119 1119. The Supreme Court explained who are Hindus and stated the broad features of the Hindu religion. In Gopalakrishnan Nair versus State of Kerala, AR 2005 Supreme Court 3053. AR 2005 Supreme Court 3053. Supreme Court stated, who is a Hindu in the most convincingly in a solemnized way, to whom Hindu law applies. That is another important aspect. Hindu law applies not only to the Hindus by birth, but also to the Hindus by religion. That is, converts to Hinduism. For reference, please not Perumal versus Kundusamy. Perumal versus Kundusamy. AR 1971 Supreme Court, page number 2352. 2352. Perumal versus Kundusamy. AR 1971 Supreme Court, 2352. Another celebrated decision is Ganapath versus Returning Officer. AR 1975 Supreme Court 420. AR 1975 Supreme Court 420. For the reference regarding the conversion generally, Chaturbuj versus Mureshwar is a helping decision. Chaturbuj versus Mureshwar. AR 1954 Supreme Court 236. So, the first point is, who is a Hindu? To whom Hindu law applies. This not only applies to the Hindus by birth, but also the Hindus by religion. That is, converts to the Hinduism. Second set of people are to the illegitimate children where both parents are Hindus. Hindu law applies to illegitimate children also, where both parents are Hindus. For more study and reference, please note AR 1934 Bombay, AR 1934 Bombay, page number 36. To illegitimate children where father is a Christian, Hindu law applies to illegitimate children where father is a Christian and mother is a Hindu and children brought up as Hindus. To illegitimate children where father is a Christian and mother is a Hindu and children brought up are as Hindus. With these introductions, I invite you to the present enactments, Hindu Succession Act 1956. It is a small act. It is the Act 30 of 1956. The chapter, I am dealing with the chapter 1 today. That is preliminary, sections 1 to 4. By completion of the sections 1 to 4, I shall conclude the class. The scheme of the Act is, chapter 2 deals with the interstate succession in general. And chapter 3 deals with the testimony succession. Chapter 4 is regarding Lipi. Apart from these 4 chapters, it also contains a schedule of KS in class 1 and class 2. When we go through the enactments, we see There are two kinds of titles for the enactment. Two kinds of titles. One long or full title. Second short title. In the beginning, we see an act to amend, and codify law relating to interstate succession among Hindus. An act to amend and codify the law relating to interstate succession among Hindus. This is a long title. Some scholars call long title as preamble. We can either use it as long title or we can call it as preamble. This is an act to amend and codify the law relating to the interstate succession among Hindus. The word amend derives from a French word which signifies to make better. To make better. Or change for the better. Change for the better. Or alter formally by addition, omission, or substitution. So, this is an enactment for amending and to codify. Codify means to consolidate into a code. It's not a mere consolidation. So, the legislature's intention was to make it as a code, so codifying. In ordinary course, we see amend and consolidate the law relating to etc. Here it is stated as to amend and codify the law relating to interstate succession among Hindus. The short title is see from the second one. This act may be called Hindu Succession Act 1956. It extends to all of India. Earlier it was stated as except the state of Jammu and Kashmir, which is not available after 2019 Jammu and Kashmir Reorganization Act. So it extends to all of India. One matter is silent in the act. This act is silent as to from when it shall come into operation. Commencement is not stated. In such a case, how we understood the commencement? In such situations, Section 5 of the General Clause Act 1887 lays down that Section 5 of the General Clause Act, Section 5 of the General Clause Act 1887, it says that where any central act is not expressly to come into operation on a particular date, then it shall come into operation on the date on which it receives the assent of the president. So, when the act is silent about the commencement, if it is a central act, Section 5 will come into play. So, date on which it receives the assent of the president. The act received the assent of the president on 17th June 1956. Hence, we can safely say, read along with the Section 5 of the General Clause Act in 1887, that this act came into force on 17th June 1956. Another aspect was the territorial operation. Now there is no doubt the except Jammu and Kashmir is removed by virtue of the JK Reorganization Act 2019. Next, we shall come into section 2. This act applies to any person who is a Hindu by religion in any of its forms or developments, including Veerasaiva, a Lingayat, or a follower of Brahma, Prarthana, or Arya Samaj. So, it also says B, to any person who is a Buddhist, Jaina, or Sikh by religion. C, to any other person who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any of such person would not have been governed by Hindu law or by any custom or usage as part of that law in respect of any of the matters dealt with herein, if this act had not been passed. So, this section applies to 3 classes of persons. Hindus by religion, Buddhist, Jain, Sikhs by religion, and any other person who is not Muslim, who is not a Muslim, Christian, Parsi, or Jew by religion. This clause raises a presumption in favor of the applicability of the act to the persons domiciled in the territories to which this act extends, who are not Muslims, Christians, Parsis, or Jews. The next important point is that the converts and reconverts to Hinduism are treated as Hindus by birth. The Perumal versus Munisami decision which I cited earlier, 1971 Supreme Court 2352. A Hindu chose to go through the marriage ceremony according to Hindu rites with a Christian lady. It was held that bride was converted into Hinduism before the marriage was performed and marriage was valid. In order to constitute a valid conversion to Hinduism or Hindu faith, there must be bona fide intention accompanied by conduct, unequivocally expressing that intention. In Guntur Medical College versus Mohan, that citation was earlier stated, that is AN 1976 Supreme Court, page number 1904. Equivalent to 1976 3 SEC, page number 411. It was said that a person born of scheduled caste parents after conversion to Christianity can, on reconversion to Hinduism, be treated as a member of the scheduled caste, provided members of the community to which the parents belonged before conversion accepted their son as a man of their flock. It is also important that the second clause, subsection 2 of the section 2, notwithstanding anything contained in the subsection 1, nothing contained in this act shall apply to the members of any scheduled tribe within the meaning of clause 25 of the Article 366 of the Constitution, unless the central government by notification the official gazette otherwise directs. So, this act is not applicable to Hindu scheduled tribes who are coming within the purview of the clause 25 of the Article 366 of the Constitution. Unless the central government by notification in the official gazette otherwise directs. Normally, there shall be a doubt about the position of the scheduled caste people. The members of any scheduled tribe within the meaning of the Article 2, clause 25 of the Article 366 of the Constitution of India are not governed by the provisions of this Act. It may be pointed out that there is no such exclusion in respect of the members of the scheduled caste people coming within the ambit of the clause 24 of the Article 366. The clause 25 of the Article 366 are excluded, not clause 24 of the Article 366 excluded. The provisions of the Act therefore applies to the members of the scheduled caste. So, in the view of the provisions of the Section 2 of the Hindu Succession Act and the ratio decided by the Supreme Court in Kasturi Devi versus Deputy Director, Kasturi Devi versus Deputy Director, year 1976 Supreme Court 2595. The order passed by the Board of Revenue was held per se illegal and contrary to the provisions of the law, since it was decided regarding the basis of the scheduled tribes. Section 3 is regarding definitions and interpretations. There are two terminologies, agnate, concepts, agnate and cognate. Agnates are relatives, male or female, whose relationship is traced exclusively through the males by blood or by adoption. Agnates are relatives, male or female, whose relationship is traced exclusively through the males by blood or by adoption. Cognates are also relatives, male or female, related by blood or adoption, not only through the males. One is only through the males and other is not only through the males. In short, the intervention of the female link makes the difference. The intervention of the female link is making the difference. Next is Daliya Santana law, Marivakataya law, and Nambudiri law. These points will be discussed only when sections 7 and 17 are discussed. One of the main objects of the Hindu Succession Act is to bring about the uniformity in the law of succession. Section 6 deals with the Vidakshara law, whereas this section deals with the family law system then prevailing in the southwest coast of India. The laws then enforced were Marivakataya law, Nambudiri law, Daliya Santana law, and Snana property law. The peculiar character of these laws is matriarchal system of descent. This system, which is alien to the other systems of the Hindu law, has now been done away with, both in respect of the testamentary as well as intestate succession. And a uniform pattern of succession is sought to be brought about to the extent possible, except in the matters of the section 7, 8, 17, and 30. It will be useful to briefly refer these systems of law which are based on mainly on customs. Those things have to be done before we go through the section 17 and section 7. And another point is the customer usage, it clause D. This clause embodies in a statutory form all the essential attributes of a valid custom. For more reference, it will be useful to go through one AP decision. Venkata Subbaravu versus Gujanjaya. AR 1960, AR 1960, 1960, Andhra Pradesh, 12. Next 2, 3 concepts. One is regarding full blood, and the other is half blood. Yet another is uterine blood. These terms are defined having regard to the ordinarily accepted meanings. Ordinarily accepted meanings are given. Two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife. They are so related by half blood when they are descended from the common ancestor but by different wives. Further, two persons are said to be related to each other by uterine blood when they are descended from a common ancestor but by different husbands. So, three terminologies, ordinary meanings. Two persons are said to have been related to each other by full blood when they are descended from a common ancestor by same wife. They are related by half blood when they are descended from common ancestor by different wives. Further, lastly, two persons are said to be related to each other by uterine blood when they are descended from a common ancestor but by different husbands. The clause F deals with heir. An heir is defined as one entitled to succeed a property of the intestate under this act. It would be enough if the right to succeed of the property, if any, is there irrespective of whether there is property or not. Sometimes there may not be property, but he may be there. Clause D says regarding intestate. A person is said to die intestate in respect to the properties of which he or she has not been made any testamentary disposition capable of taking effect without creating a will or codicil, etc. The last one, the clause there deals with related. Related means related by legitimate kinship. Legitimate kinship. Provided that illegitimate children shall be deemed to be related to their mother and to another and also to their father, if not. And legitimate descendants of such children shall be deemed to be related to them and to another one. And any word expressing relationship or denoting a relative shall be construed accordingly. Earlier, while the act was in the form of a bill, the Joint Committee in its report stated that the definition related has been so modified as to enable the illegitimate children to succeed their father, if father is known. The Parliament rejected the amended definition and incorporated the present definition. Illegitimate children are those born outside the lawful wedlock. Hence, the legitimacy is an express precondition of the relationship, which alone can constitute the foundation of the right under the Act for the matter of succession. Hence, illegitimate children cannot be included within the meaning of the word son or daughter, or son of the predecessor son or daughter, the daughter of the predecessor son. And so in the class 1 and class 1 the schedule. Now, let us go to the section 4, the last section of the chapter. Overriding effects, same otherwise expressly provided. Section 4(1)(a) refers to traditional Hindu law having its source in the Smritis and commentaries such as digest, as interpreted and applied by the courts in India, and custom and usage which are recognized by the courts as law and incorporated into the personal laws of the Hindus. Clause B refers to statute law governing the Hindus made from time to time with a view to rationalize the personal law. By 2005 amendment, clause 2 is omitted. Only A and B are here. There is a drafting lapse. You can take note of it. When subsection 2 of the section 4 is omitted by the Hindu Succession Amendment Act 2005, figure 1 denoting the subsection 1 would have been deleted. And now I conclude the class by completing the chapter 1. And I say a word of gratitude to all who allowed me to present this class. Thank you.
Sir. Any doubt? Samosa. Answer or doubt ഉണ്ട്.
അൺമ്യൂട്ട് ചെയ്താലേ അവർക്ക് ചോദിക്കാൻ കഴിയുന്ന ചോദിക്കട്ടെ.
ഓക്കെ, ഗോപൻ സാർ ചോദിച്ചോളൂ. ഗോപൻ സാർ, വേണുഗോപൻ സാർ, വേണുഗോപാൽ ചോദിച്ചോളൂ.
സാർ നമസ്കാരം. ഞാൻ ചോദിക്കാൻ ഉദ്ദേശിക്കുന്ന സാർ, നേരത്തെ ഈ 1956 മുമ്പുള്ള കുറച്ച് ആക്ട് പറഞ്ഞപ്പോഴേ ഹിന്ദു ഡിസ്പോസിഷൻ ഓഫ് പ്രോപ്പർട്ടി ആക്ട് 1960 1916 ഒരു ആക്ട് ഉണ്ട്, അതിനെ കുറിച്ച് അതില് ഈ ട്രാൻസ്ഫർ ഓഫ് പ്രോപ്പർട്ടി ആക്ടുമായിട്ട് ബന്ധപ്പെട്ടതാണ്. അതിന് ഇപ്പോഴത്തെ സ്ഥിതി എന്താണ്? അത് കംപ്ലീറ്റ് റിപ്പീലായോ? അതിന് എന്തെങ്കിലും പ്രാധാന്യം ഉണ്ടോ എന്നറിയാനാണ്.
സാറേ, ഞാൻ കുറിച്ച് പറഞ്ഞായിരുന്നു. ഞാൻ പറഞ്ഞ ഇതൊക്കെയാണ്. The caste Disabilities Removal Act 1850. Second one is the Hindu Widows Remarriage Act 1856. Indian Succession Act 1925. Converts Marriage റിസർവേഷൻ